On Tuesday, the High Court in Accra heard the Mandamus application brought before it by some 4 parliamentary candidates of the NPP, that is for Tema Central, for Ablekuma North, for Okaikwe Central, and also Techiman South. Now, this became necessary because earlier the Electoral Commission had declared the results of these constituencies in favor of the NDC, a move that the NPP would describe as unlawful, because according to them, the entire declaration was done based on half results and also due to some intimidation from NDC supporters. Now, today on the Channel One newsroom, we bring you highlights of what happened in court and also reactions from all the parties involved. But first, let's go over to my colleague Hansen Ajman, who sat in court throughout the proceedings.
The NPP, the Electoral Commission, and the NDC came to court on 4 constituencies: Techiman South, Okaikwe Central, Ablekuma North, and Tema Central. The plea of the NPP, who are plaintiffs in this matter, is that the court should order the Electoral Commission to go back and collate results in these constituencies. These constituencies already, the results had been declared for the NDC. The NPP earlier came to the court for a Mandamus application that calls for a collation, or what has become to be termed as recollation. After that, these constituencies were declared in favor of the NPP, except for the Ablekuma North constituency, where the officers were not able to complete the collation exercise. However, the NDC went to court saying that at the first time when the Mandamus application was being heard, their arguments were not listened to, and that their right to natural justice, which is a right to be heard, was not upheld by the court. As a result of that, the Apex Court decided to quash the decision of the High Court. The Apex Court, however, directed the parties to return to the High Court to rehear the Mandamus application. But before that application could be moved, the NDC's lawyer, Godwin Eduje Tameklo, moved a preliminary objection, arguing that the court lacked jurisdiction to hear the matter because of the approach that the NPP used. He argues that if you look at Section 16 and Section 20 of PNDC Law 284, People Representative Law, as amended, any issue as to whether or not a person has been validly elected or as to whether certain results should be cancelled can only be made by way of a petition to the court. Because of that, any other attempt to use any approach, such as a judicial review, as the NPP used in this manner, is a way of circumventing a proper hearing of the matter where evidence will be properly heard. The NPP, however, opposed this and argued that their case does not deal with the issue of declaring or cancelling results. Their case deals with compelling the Electoral Commission, which has a public duty, a duty to conduct elections, to supervise elections, to collate and declare results. They say that from their observations and evidence available to them, the Electoral Commission has not done that, and the Commission itself has admitted to not doing that. As a result, the court should compel the Electoral Commission to go back and do its work. The court, after listening to the parties in the case, including the Electoral Commission itself, whose lawyer also supported the idea that the Mandamus application should be heard in the first place, decided that it will adjourn the case to tomorrow, January 1, 2025 at 10 a.m. and it will give a ruling. At the moment, we'll try and see if we can interact with the New Patriotic Party. Is your side feeling frustrated? Because, the options that we've used all, the NDC appears to be blocking your chance of making your point.
We have every patience for the law. a court process may be slow, but with surety, you will get the results when you know you are on firm grounds. What it is about this, simply put, the Electoral Commission itself has stated with emphasis that there is no such thing as a declaration of results in Okaikwe Central, Ablekuma North, and Tema Central, as well as Domiko Abenya. So they have already administratively declared those results as illegal. And the Electoral Commission is doing its work. So this argument that they are declared results is neither here nor there.
I argue that if the Electoral Commission has agreed that there was no proper declaration so-called, this could have been corrected by an administrative fiat. Why didn't you engage them to do
this? Is what they have done. You remember that we were all at Tesano police station. There was an agreement that we should all be at Tesano and do the collation. We were at the Tesano Police Training School. On Thursday, we agreed to do 4 constituencies. When they realized that we had won all, that was when they started making their noise. Then they threatened the EC. And in the process, EC wrote to the police to provide protection. And it was within that period of delay that we came to court for an order of Mandamus and also for the EC to be protected by the security agencies so that they do their work. That's the application we're on.
Doesn't it make sense to say that determining if an elections have been properly conducted and concluded and determining if somebody has been validly elected are two separate things?
No, they are not the same thing. You see, it all talks about the outcomes. What is the outcome? The outcome is about election results, right? So the simple argument they were making was that Section 16 and 20 of the ROPA Act, that is PNDC Law 284, says that there are 4 grounds you can challenge an election petition, right? And it has been that you are talking about intimidation and the rest. And we are saying that within, you cannot come under Mandamus says that they should perform a public function or public duty